Today, we have Erin McCarthy on the legal side of nonprofit technology. Erin is the founder of Erin McClarty PLLC, and she helps clients worldwide create the worlds they want to live in by working with businesses, charities, institutions, and movement leaders to form structures, documents, and business models that reflect their values, dreams, purpose, and mission. So all done through focus healing tools, community, and education. And I'll put the link for Erin's website as well in. And with that, I'll turn it over to you, Erin, to start things off.
Thank you so much. I know that's a mouthful, so I appreciate your dedication.
You're welcome.
I will go ahead and share my screen now. Actually, I guess I can put it in.
Yeah, if you could put it at full screen, they'll probably see.
There we go.
Fantastic.
Perfect. Okay. And Joyce, I will rely on you to let me know if anything goes wonky since I can't see literally anything right now.
Okay, okay, great.
Okay, perfect. So I know that we don't have that much time together, everyone. I won't spend too much time talking about myself since I had that wonderful introduction. The summary, if you take anything else away from who I am, is I help people translate their ideas into life-changing projects, programs, and initiatives. I am an impact architect, but attorney by training. And so that is why I am talking to you about the legal side today. To that point, here are some of the topics that I'm going to cover: privacy, IP, intellectual property, online programming, fundraising, and then just overall how to protect the organization. However, keep in mind, my intention is to not to make you a legal expert. You'll have to spend a mortgage to do that, just as I did. But my intention is to give you just some things to be thinking about as you are going about your day-to-day, so that you can say, you know what? I remember Erin talking about this. I may have a privacy issue come up. Or you know what? I remember Erin brought this up. I may have a online programming issue come up. So really what I'll focus on are triggers, at moments where you start to think, okay, you know what, there's more to this that I should be looking into. And then I always tell clients, the intention is not for you to know everything, right? And so once you know the triggers, at least, then you can start reaching out to the appropriate people to be thinking and co-creating solutions around, or even brainstorming around what may come up. So if I know I have a privacy issue, I need to start talking to some people in IT. I may need to start talking to an attorney or to someone in the privacy space. And so it's really more of a way of helping you problem solve than understanding what every single law is. So I'll start with privacy. Really, the trigger here is anytime you are collecting personal or sensitive information, you will have yourself a privacy challenge. And so when I say personal or sensitive information, what's important to keep in mind is that this definition actually changes depending on the law that is applicable or that you're talking about. So some people don't think that addresses or email is that sensitive of information, especially since we give out email out to everyone, but most laws do define emails as sensitive information. It's just interesting how much it can change. So keep that in mind when I say that. As far as the concerns, of course, is keeping info private, making sure that you're abiding by the laws, and it matters for a few reasons. So a lot of people don't know that, one, there are state requirements around data collection. So when you are collecting email addresses and horoscope signs and all the other things that people are collecting these days, there are many states that have laws around what that process has to look like. Because there are 50 states, there are a number of different ways in which the laws are written and a number of different ways in which they require that data be collected. Even trickier, most of these laws are what we call long-arm statutes. What that means is they attach to the people and not the place. So when you look at data privacy laws in California, it often attaches to the people, Californian residents, not necessarily where those residents are accessing the website or whatever the case may be in which the data is being collected. This is really important because I have nonprofit clients who may be in Maryland who think they're only responsible for Maryland law. But if I'm collecting information from California or from, I'm trying to think of another one, Pennsylvania, then their data privacy laws will also likely apply with respect to those individuals. And that's something that I have to be aware of, not only in how I collect that data, but what happens if there is a breach of that data. Then there's federal law to be thinking about as well. can spam, having contact information and opt-outs and things of that nature. And then international privacy law. GDPR is one that I'm sure you've heard a ton recently. So thinking about that, thinking about the laws in specific countries that can vary. So GDPR is European Union, but there's laws throughout African continent that have differing requirements in terms of data collection. So all this to say, the smaller the organization, the more overwhelming it can be. If you are a small organization collecting information, you may not be able to be thinking about the entire world and its data collection requirements. So what I tell clients to do is be looking at who you're collecting data from and watch for trends. If we're getting a ton of signups from California, maybe start to look into, is California high risk, which it is. Okay, what are the things that we need to make sure that we have in place, both in terms of data collection and then if there's a breach, because there's often a breach protocol. If we're collecting a lot from European countries, then are we compliant with GDPR and how information is accessible, and the language that has to be in our terms of use is one way to work around all of that. So when this comes up, newsletters, online accounts, payment processing, things like that is oftentimes when we need to be thinking about privacy. Making sure I didn't miss anything. Oh, also keep in mind that many of the state laws and sometimes federal around privacy have protections. So if you have a minimum standard of protocols or protections in place, then they kind of give you the benefit of the doubt and say, you know what, hate the player, not the game, not your fault. We get it. So we're not going to penalize you on this level, but we're going to ask that you go through the following to make sure that everybody's A-okay. But that only applies if you have the minimum level of protections. All that to say, not doing something is not an option. Do something, right? And then again, look at where you're collecting that data to see, well, what is the minimum protection that we need to have in California versus the minimum protection versus in under GDPR. Get those in place so that you can avail yourself of those. It's called safe harbors. So protections for at least trying to protect people's data. Intellectual property is a biggie. This comes up anytime you're creating or using content, and it's really a concern in terms of ownership, licenses, limitations that you need to be aware of, and making sure that you don't infringe someone else's intellectual property. So where this comes up is, let's say I have someone who is developing blog posts for my website. A lot of organizations forget I don't own the copy that they develop. Legally, technically, copyright goes into the author. Right now, there is work made for hire, and there's a whole thing around that. To be safe, if I want to make sure that I own the blog posts and I can use the blog posts in any way that I want, I need to have some type of arrangement, written arrangement, with the person who's drafting that, either giving me ownership outright under the work made for hire, or I need to make sure that I have a license to use it. If I don't have a license and I don't have ownership, but I use those blog posts, I'm technically infringing that person's right. They may not say anything now, but where this can be problematic is the relationships can go sour. And in the future, if this person decides they want nothing to do with me, they can say, you know what, take all my content down. I want nothing to do with this. Take it down. I'm taking it back and I'm giving it to these other people, which they have every right to do if they have ownership. So if you are having content developed for you and you want to make sure that you are able to use it in ways that are appropriate for the organization, putting in its newsletters, sending it out to donors, etc., make sure that you have something in writing that outlines what that relationship is supposed to look like. To that same end, when I am allowing people to use my information, my branding, and things of that nature, there needs to be a license in place to make sure that I'm protecting all of my intellectual property. A problem, or what the problem can be, is if I don't do that, not only am I making myself at risk for abandonment, so that basically means I lose my rights in my intellectual property, my branding, because I didn't protect it, but it also just allows other people to infringe on it. So anytime you are allowing platforms, partners, etc., to use your logo, to use your name, any content of yours, there should be some type of license agreement in place. And basically in that, all you're saying is you can do this, you can't do that, you can do this, you can't do that, and you go from there. As far as why it matters, you want to make sure, of course, that you're on the right side of any federal and state laws around intellectual property. And then you also just don't want to be in breach of any type of contracts that you have around intellectual property. Making sure I covered everything here. As far as protecting yourself, as I said, make sure that you're papering everything. If you're having a logo developed, there needs to be something in place that addresses your ownership of that logo. A lot of my nonprofit clients have no idea how little they own because they didn't get paper in place. You may be thinking, oh no, I have all these things I don't have paper in place for. You can always go back and get it, right? So if I have anyone developing a database, websites is especially important. I can't tell you how many people I know who have been held hostage under their websites where they had a creator, them and the creator started to have a falling out. The creator changed the passwords. Now the nonprofit doesn't have any access to the website. I've seen this happen dozens and dozens and dozens of times. So that's why it's really important. If you have ownership of that as it's being made, if you have the passwords, if all of that is written out in writing, then there's more of a route toward making sure that you continue to have accessibility than there isn't if you don't own it. And then you can also just think about a policy, having a policy. When I say policy, because I know so many of the organizations I work with have a smaller team, that can truly be half a page. It doesn't have to be an illuminated Bible in terms of length, but just having some type of policy for your team in terms of, hey guys, or hey all, when you have things developed, make sure you have these contracts in place. Make sure you're getting this language in there and that we own it, or that we have the right to market and reproduce and publish, and all the other magic language that you have to have from a legal perspective can help out a ton. Online programming. So everyone with the COVID restrictions is turning their programming online, which is incredibly helpful. As you are doing that, be reading your terms of use. You may be surprised by how many rights or maybe you're not, but you may be surprised by how many rights a platform is reserving for themselves through your use of their platform. So for example, do they have a right to reproduce your content whenever they want, however they want, without asking you? Most platforms do. And so that may be great if they have a great audience and you don't mind, but I have seen situations where platforms have tokenized, to be frank. And because so many of my clients, my nonprofit clients in general, are working with vulnerable populations, that's something that we have to be vigilant about. And so there may be a use that a platform has that you don't necessarily feel comfortable with. And you want to make sure that you're aware of that possibility and any possibility to opt out if you want ahead of time. So reading those terms of use, both in terms of the general terms of use, privacy policies that they have on the website, and then any specific terms of use they may have for the product you're using is going to be really, really important. Also seeing what your ownership rights are. I have started to see some platforms that have ownership rights over content generated through that platform. Crazy, I know. That can be really problematic if you end up getting locked out, hacked, you don't pay, they lock you out of the account, whatever the case may be. And so reading all that and making sure that you're clear as you go online as to what the rules of using those platforms are is going to be really, really important. As you start using software a little bit differently, also be keeping that in mind. So if we have a certain amount of software license seats, are we using more than what we've purchased? If we only have one seat, and by seat, I mean basically one right. We bought a license for one person, but now we've got 10 people using it because we're all working from home. When you true up those licenses, that may get really expensive with penalties. So just be aware of that and making sure that you are paying for what you're using. And then, of course, making sure that you have protections in place against hackers, especially when you're working with vulnerable populations. There's been a lot of instances of the Zoom bombing, bombing on other platforms. There's been examples of eavesdropping on vulnerable populations. And so having those protections in place is going to be really important. And as far as online fundraising, let's see, I'm checking my time. Okay, 5 minutes. As far as online fundraising, just making sure when you're soliciting funds, one, we're keeping in mind that each state has its own laws around solicitation. Less of a tech issue, more of a just logistics issue, but I bring it up because a lot of organizations don't know or don't remember that, I have to register in California before I can ask people for money in California. I have to register in Georgia before I can ask people in Georgia for money. What does that look like? Can it be passive? Can it be active? Each state is different. So for some states, merely just having a website that asks for money that a citizen happens to donate to is enough for it to trigger their requirements around you in doing their solicitation registration. For some states, you have to be super active. So that means reaching out to people, having fundraising campaigns, emailing people directly. Where this can become tricky is Let's say it's a state that requires an active solicitation. I may have them donate to my site. I add them to my database the next year or for my end of year campaign. Then I email them. Now I've triggered the active requirement without even knowing it. So just being aware of those things, making sure that you're registered. Similar to the information collection, you may not have the capacity to do that for everyone. And so just trending to see who you're getting information or in that case, fundraising from is going to be important, because if you don't, then there might be some fines and penalties. As far as protecting the organization, I've kind of talked about this generally, just making sure you have workflows and approvals, that you look into the laws, because ignorance is not bliss, trust me. And develop policies and even templates, ahead of time, especially when you're contracting people to do things for you. Because if you have the contract templates, then you can already have that language that you need in there around licenses and use and things like that to make sure that your bases are covered. So I'll stop there, breathless, to see if there were any questions before I close out, because I know we have just a couple minutes left. Joyce, you're on. Are you talking to me or on mute?
Yeah, no questions so far, but if folks have questions, please feel free to add them in chat. I guess for those who are doing, you were just talking about donations across, and donations are such a tricky thing, because as you said, folks might be getting them in from states that they're not even necessarily know what they're triggering for that. Like, do you have any more broad advice beyond, or other advice beyond that for that sort of situation? I think that would be good.
In terms of the fundraising?
Yeah, because I think that's something that probably...
There's people who do, okay, comes up for them. So there are people who do it. They can be expensive. I guess I think the best thing is to just be looking at your platforms to see who is donating. And then if I see that I have a significant amount of people coming from New York, then I know I probably need to look into New York's law. There are some websites from the donation perspective that will tell you what the most stringent states are. And so California is definitely one. New York is another one. Texas is a little bit more on the more lenient side. Being aware of those states is also helpful, so that if you see them coming up, then you can be thinking proactively. I know I saw a couple of questions. So, of course, as the attorney, I have to give the disclaimer that none of this is legal advice. Should have given that up front. But I bring this up because I see the mention of the templates. Be very careful, of course. I always have clients just put several of their agreements that they need together for cost-saving measures, because I can't tell you how many templates I've gotten, and it has New Zealand law, or it has language in it that the client didn't really understand, but was totally opposite to what they needed and actually hurt them. So I would never use something that was developed for someone else for myself without fully understanding what the language is in that. Even having an attorney review it just to make sure that there's nothing in there that's going to hurt you is probably going to be really, really important. Harbor Compliance is a great website. Someone just mentioned in terms of the restrictions. That's one of my favorites. And then someone asked about the don't house or host outside. That was merely to say, try to keep everything internal to the extent that you can, because the more that you have externally hosted outside of your control, the more likely it is that you may have a liability issue come up if their protocols are not as stringent as yours.
Any other questions? We still have a few minutes.
Oh, do we? Okay, that's why I'm like running through this, because my time, I wasn't sure.
Yeah, we still have time. So if there's anything else you want to go into or a little deeper, that's fine too.
Awesome. Privacy policy. So there are depots, again, template depots for privacy policies. What I like to say is look at some of your favorite platforms to see what they've included. Because I have had clients do that, and I've said, look and see what these people have in theirs that we need to make sure that we cover in your privacy policy, and then we put their privacy policy together. The range in terms of how much it can cost can be anywhere from maybe $500 to, I don't know if I would pay $1,000, but if it's long, it can get to that point. I cannot tell you how helpful that $500 to $1,000 is. And usually you can do them in a package, right? So it's your terms of use, your privacy policy, and because of GDPR, people will do a cookie policy and your DMCA policy and all of that. So get all of that done together and out the way, because again, I've just had clients that have put language in their templates that they didn't understand that ended up shooting them in the foot. And that's not what we want to do.
So Jane has a question too. Should nonprofits
see.
be concerned about the websites being accessible for people with disabilities from a legal perspective? So businesses get sued frequently. What about nonprofits?
Absolutely. That's a great question. So just from an equity perspective, absolutely. An inclusivity perspective, absolutely. From a legal perspective, which I appreciate the differentiation, a nonprofit is a business. And so ADA and all the other requirements absolutely apply to nonprofits similarly. The enforcement in some states may be different, but there's definitely this myth of, and I'm not saying this is Jane, but I have it in my own clients where they say, well, because I'm doing good, they kind of give me a break. Some states will, some states, especially around seasons like this, want to make an example of organizations, and that can include even small organizations. So the technology can get expensive sometimes. Commercially reasonable efforts is usually what people are asking for. So looking to see what sources, partnerships are great to this end. Working with nonprofits that work with those along the physical spectrum will help with finding some of the free platforms that do allow for your websites to become more accessible for those who may be physically challenged. Partner up with organizations that work with those respective populations because they know about the different apps and things that I can use for clients that are more cost effective than some of the larger business oriented interventions that get used. Or I hate to say business because nonprofits are business, but you know what I mean.
Mm-hmm. And Suzanne had a question about, do you have any advice on electronic signature policies, which I imagine is very important in COVID times?
It is. It's so interesting. So one of the reasons why that was so important years ago is because most states didn't allow for electronic signatures. And many, I think Texas, no, I think we did adopt one. Many still don't because it's just kind of a given. What I would say is, and this is putting on my hat from when I was with a Fortune 500 company, one of the biggest issues with the electronic signature is just fraud, right? And forgery. So just having something quick that talks about that. If you allow others on the team to use an ED signature, you'll absolutely want a policy for that. I wouldn't recommend it, but I know it's a practice that is used, especially for smaller teams. So having a process around what that looks like. Apps like Adobe, which is maybe $20 a month, will actually have a chain of command that has to go through. And so there's some apps that in addition to a policy, will create workflows that ensure security and permissions. And so if someone was to use my signature, I would actually get dinged. I'd have to approve. Then the signature gets applied to the contract. And so looking into some of those would probably be helpful as well. But it's ironic. I wouldn't say that the electronic is as important as it's historically been, outside of just making sure that folks aren't using electronic signatures all willy-nilly.
And Jane added in, should nonprofits get some sort of insurance to protect them in case they are sued for defamation, libel? How affordable is this, and where should they look for that?
No, and I appreciate the ringer question, Jane.
Yes.
I have a lot of accessibility advocate friends, so I am learning myself. So yes, I would get insurance. There's a number of different things to be thinking about with insurance. And of course, I appreciate the question about affordability because they can get expensive. So, cyber insurance is becoming a biggie. For some organizations, especially those that are collecting a lot of information, that may really be something to look into. In addition to that, you do have board insurance. You do have insurance for errors and omissions if we're consulting. And then, of course, as mentioned, there's insurance around defamation and libel. What I would do is I would look at programmatic activities of the organization. What is the highest risk? There's always a few activities for my EDs that keep them up at night. Looking at those activities, then I would start to look at insurance policies. It's not to say that the others aren't as important, but I would definitely prioritize. I would also prioritize in terms of risk and exposure. So, if we're not on the computer a lot, if we're not asking for a lot of information, then the cyber policy may not be as important right now as having board and officers insurance, for example, or having some type of errors and omissions insurance for our staff, or vehicle insurance for our fleet if we have staff who are doing a number of different things. And so it really just depends on that. Travelers is a great one that I hear a lot of my nonprofit clients bring up. CDFIs, I've noticed, the Community Financial Development Institutions. We're going to get there somewhere. CDFIs are a great resource for insurance now for communities more often than not, and they usually are very accessible in terms of pricing. If they don't have an insurance vehicle, they usually have a partner that they're working with. So I've had some of my clients go through them as well and would look into those. I know that there was a question about IP. policies on agreements for IP. So again, as far as the policies themselves, there are a couple of websites like Lexology that are mostly for attorneys, but every now and again, because they're all attorneys that write these, they'll have policies and things that they post following things like that. So Lexology, Lexology, and JD Supra, JDSUPRA, both have resources that come out from attorneys. It can be a lot of legalese, but they have great resources that are usually free. So that's a good one to look at. I'm hesitant to recommend, again, some of the depots because I've read through them and not everyone gets their stuff checked. And so not everything is of the same quality, but starting, I think, with some of these legal sites and seeing what they talk about and what they're bringing up as legal issues is a great start. You're also going to have better vetted information than when you would with like an Ask Core or some of the other resources that I know a lot of clients like to use.
Oh, so wrapping up with 3 minutes. So I guess any final comments, Erin? I mean, I guess anything that you've seen that have popped up maybe during COVID that have been questions or concerns? I know that's a big question, but
yeah,
since we have just like a
few minutes. Yeah, no, absolutely. I'm glad you asked because I'm looking through and making sure with my notes I covered everything. So one that I would keep in mind is as people are trying to engage with folks offline or online more often, be careful what information you're asking for. Do we need blood type? You know, I fill out so many forms from nonprofits where there's just 1,000 different questions. And I wonder, do you even really use any of this? Because again, the more information you collect, the more exposure you're creating for yourself. And then if there is a hack, that's more liability you have with respect to the gravity on the spectrum of really kind of okay bad and really, really, really bad. So just being careful with what you ask for. You know, to the extent that something is not your expertise, like credit processing, and you're asking for information for that purpose, then using one of the biggies is going to be important. Make sure that you have disclaimers on your website and disclaimers in your agreements with users around third parties. So Blackstone, I think it was, or Blackbaud had the really big IP breach of their system. Nonprofits can often be responsible for that because they were the ones that gave Blackbaud the information. And so having something in your terms of use, you often see this where it says, we are not responsible for the policies, procedures, or actions of any third-party site that you access through us or credit processors that we use. In this case, donation platforms that we use is also going to be really, really important. And then, of course, be careful with any social media and sweepstakes. There are very specific laws that the FTC has around ads, sweepstakes that have to be included in the body of the language. There is a PDF that they've created for influencers, but it really applies to everyone that uses social media for sweepstakes and contests and things like that. So make sure you download that and that you're aware of what those laws are.
So with that, we can wrap and thank you, Erin, and for this. This has been, I think, very insightful and hopefully helpful for everybody in the audience.